assuming what you say was the case, the problem is that already he had suggested a date. Probably you may not have been aware that is on that day. But at the same time, we could have applied flexibility in the sense that the NCOP starts at 8:30. The problem is that the second letter that comes is not only the appearance in front of the select committee in the NCOP, it has got a special cabinet meeting, which means even after the NCOP, you will not be able to get hold or access to him because he's going to a special cabinet meeting. So that is precisely that reason. So can I look at whether that's what honorable members now are suggesting? Then we will go the route, because here as a committee will take principal decision on the question of the subpoena. Then legal services can help us on the procedure to follow. Can we do that? Because the decision must come from you as committee members. The implementation of the decision, the administrative process or procedure, it's what the legal services can deal with. But also I think it will help members so that when we take a decision, we understand what decision are we taking. I want us to put first this issue aside that Honorable Khawula and Honorable Beginning were suggesting until you assist us, whether that procedure, remember, there is no date, but there is a week. So that when they brief us, we don't do, I'm making an example, balancing the process of subpoena and the fact that whether that subpoena would kick out what is being suggested. Because it's suggested so that we don't create an impression that there is no suggestion of next week or whatever date we would give, which is another matter, whether next week when that date is given, you will then come here again and sit and say there is another reason. That's a separate process, but I think legal services will have to give us, or whether simultaneously you can implement both processes at an administrative level to say here, but in the meantime, this is what we are doing. I think they can help us. But the principal decision stands that there has to be, he now has to be subpoenaed. That is the first thing. The second thing is that Honorable Smith was suggesting, or Honorable Lorim, either way. And I think all members seems to be in agreement that we need now, as a committee, to move the step further. Remember, it was the House Chair who said, before doing anything, first interact with your minister at the level of oversight, executive actions. Now the question arises, will you forever until, I don't think that to me was a condition. Now I want to, if members say this, then to say, firstly, there is a decision that is being proposed that we subpoena the minister to appear before the committee. We will deal with the issue of the legal procedure to be followed, including the fact that there is a suggested time period that is proposing or committing to appear. The second thing is that the committee agrees we must go for an investigation in the form of other investigations that have been instituted by other committees, taking an example of the process that is being followed by the Committee on Public Enterprises. Secondly, we agree that this process, it has to start as soon as possible. Can we then go to what then is the content of the process? One of the issues I want to be upfront is that with the committee, with what we have now in existence, you will require to have an evidence leader. You will require to have dedicated personnel staff. if it can't be the committee secretary, because there could be many other issues, because the committee can't stop doing its work on the other side. Thirdly, we will apply for separate days from the origin. It actually means members, with due respect, must be prepared to even meet on awkward times and awkward periods, because we also have an operational duty so that we don't collapse the committee from doing its work simply because we undertake this process, this exercise outside. It will require, therefore, honorable members, those who serve in two committees, to really, if it means to all of you, we must go and plead with your chairpersons of your committees. We can plead with them so that we undertake this work, if that members what to do. Secondly, is that we need to develop the basis, or I don't want to say the terms of reference. What are these key issues that this committee must undertake? And I think honorable members must also be able to assist us. From the House Chair's point of view, it is about state capture, where that's what the letter said. It's about state capture allegations that involves the minister. Surely the overall, the broad thrust of that is to investigate whether is there any issues of state capture that as a committee, I don't know, I may not be using the correct phrasing, but we have to establish that. And what are the key issues in relation to that, especially in terms of the execution of executive actions? Should we allow that until the first process of what constitute is done, and then look at what are these key areas of focus? There are many issues, obviously, that emerges. It could be, what are the origins? Are there any origins where we say this is a matter of recurrence? Can we tackle issues that are external, or we use them as references? But I would say even consideration then will have to be made on areas where they impact on two committees, because we have to establish whether is there. My understanding, which again when I spoke to the House Chair, was that you still have got a responsibility, an oversight responsibility with regards to this matter, regardless of other processes that are taking place. So we have that duty, and therefore we have got, what do you call it? Now I can ask you, Advocate Schmidt, we don't need to prove things beyond reasonable doubt. We look at prospect. What is it? Balance of probability. See, oh, no, I can't trust that comes from an overall. I must get someone. I'm joking. Okay. Honorable members, I'm still throwing, I will come to you, legal service. I want members to take decisions themselves so that they don't say, no, we were compelled, and then you becomes the ones that we must take responsibility for our duties. Can you help me on that? Now we agree on the question of the investigation, constituting a body that will conduct this work, probably look whether there are any extra costs that will come in. We agree also if there is a requirement or a need for expert opinion or expert work, we will deal with the issue as and when it arises. We agree if there is something that will require external excursions, it will be on the basis of the work that the committee is doing. The next issue now is that, what do you want this investigation to do? Honorable Jafta, Honorable Khaula, Honorable Khaula, Honorable Jafta, Honorable Lorima, Honorable Schmidt.
I think first from my side is the clarity. I want to believe that what propelled us from arguing for a subpoena of the minister is informed by the refusal to attend the meeting. And as a result of that, because we want to do our job, we then said that it must be subpoenaed so that we're able to exhaust ourselves, you see. And my understanding, I'll be advised, my understanding is that on the basis of him coming through the subpoena, we'll then be able to take a decision as whether there is what would be called a prima facie for an investigation. You see, I'm not sure now if these two processes, because I was thinking that the subpoena will precede a decision for investigation, you see. But seemingly now the decision is that we are taking this decision simultaneously. So I just need clarity there, you see. And then I think the other one will just be a follow-up after I got clarity on the issue of investigation.
No, thank you, Chair. I think I'm closer to Honorable Khawla. I thought we will be able to take, assuming that we are agreeing on what you have been saying, I thought we will be able to take tangible decisions after the legal team has advised us maybe on whether we can do both simultaneously, or we start with this issue and then follow with that one.
Yeah, just in reference to what my honourable colleagues have said, the way I understand it is that we were asked originally to give the minister a chance to account for himself, which he did, the first time he came, which Honourable Kawula wasn't here, but one of his party representatives was. We conducted that process. We've now given the minister ample opportunity to come back and continue answering those questions, opportunities which he's declined. So essentially, I think, for me, the decision is, well, now, that's fine. He's had his opportunity. Now I think there is sufficient in what I've heard already for us to move to the stage of a formal investigation. During that formal investigation, there will come a time when we want the minister back, at which point we subpoena him, when we are ready. It may be that we decide as a committee to have him first, but it may be that we have other people testifying before the committee first, before we ask the minister back. So when the time comes, we do subpoena him, but not necessarily before we commence the investigation.
Mr. Chair, would you like the issues on which the formal investigation should be conducted? Is that what you're asking?
That's exactly what I was asking. But, the problem when you've got a confused chairperson, the entire meetings get confused. So let me be the one who avoids to be confused. Because members had suggested, and I think there's a point, but the problem, Honorable Jafta, I always avoid to put the legal team, any of the officials of Parliament. It's only when ourselves have said, this is the decision we are taking, then they can advise us. If they say, but your decision that we are taking may have these following limitations, we can then review the decision. But I ran away from a situation where they tell us that you can't run concurrently. You must take a decision as a committee. The question of concurrency, or which they can go together or some will come later, is an issue that is flexible to change, but you have taken a decision. I don't want people who don't take decisions. They first test waters first before they take a decision. Take a decision. Now, my understanding was this one, and the reason, and I think Honorable Khawula is correct, the reason I didn't follow this thing, there were members who felt, maybe let's try and dramatize or try to sidla this cash. There were members who said they had not finished or exhausted their questions to the minister. They will want to have a second round on those issues. We even in discussion said, maybe we must begin to narrow down even those questions to relate to the execution the performance of execution actions in relation to the department or the minister. But the reason then is that they needed the second, it's not that the minister is compelled by the fact that he has not come. They needed, and the minister at that point did not said, no, I'm willing, I'll come if you want me to come back again. The issue now is that under normal circumstances, we should have gone to the next process at that point. But then we said there was a view that no, let's first exhaust the first ones. And now members say, that's why I said, they say, no, look, whilst you are pursuing the issue of the minister, set the other process in motion. Because that process, it is not subject to or not the minister per se appearing. It is subject on the fact that, do we think is there something or a case to follow here? Now, when you looked at the issue, the opening remarks of Honorable Smith, he says, already there is, even if we can argue that does it relate here or not, it's a subject of that process. He says there's prima facie case because already there is an issue that implicates the minister in relation to the external dairy farm. Can you then say we will wait perpetually? So it actually means, depending on what the legal services will be saying, at this stage, you are of the view that there has to be an investigation. It has to be constituted in this format. How does it take how does it take forward? It is subject also on how far have you constituted it. If we were to follow the subpoena, let's assume there is dispute and everything. I don't know, I still have to, I said, I was told by one law lecturer, don't question the law, you must ask the law. So in my asking of the law is that everything that you put into motion that is legal, it can be subject to another process on its own. Will this, I'm just saying, when they explain to us, if the minister comes back and say, no, I'm just being hypothetical. It is not true that I refuse to come to the committee. I have always been committed to come to the committee. I have given them reasons why I'm unable to come to the committee. They have accepted my apologies and the reasons of not coming to the committee. But on the basis of that, I'm also of the view that when I state these things are not necessarily correct, and therefore I dispute what is being said. I'm just being hypothetical on something that is unfounded. Because in my view, when you subpoena someone, that person in law is entitled to refuse your subpoena and challenge you legally on what you are putting forward. Must we sit and then say, we will wait for that? That's why I was saying, to me, the only concurrent process I can talk about is what the committee is doing and the fact that the minister is being subpoenaed. But let me be upfront so that I put them at ease. The problem that we might have is that, I think Honorable Lolema, if that's what I was saying, I don't want to jump the gun. When you start an investigation in the form of what is there, it's no longer a question whether you come or you don't come. You see? Because now you are a subject of an investigation. In this case, the minister is not a subject of investigation. So when we conduct investigation, it's what I think Honorable Member was saying, then you can, the minister, then the committee will say, we want to question you in relation to the evidence presented in front of the inquirer. So even there, if he's not coming, it actually means you put another second subpoena now as an inquirer of Parliament. But I thought members were saying, look, we are ready. With what we have, we think we must go to an inquirer. The issue which I think to me remains a sticky point is that even if you were to allow that, and I think I must be upfront, my fear, and it will be a sad day that when I was presiding over the committee, it sets a precedent. If someone were to decide not to come, of which I'm not saying the minister said is not coming, I think the issue is that confirmations of coming have been received, but reasons of not coming at the same time were received. So you have got no guarantee even on what is being proposed. Now, the fear that I have is that if as a committee you leave some of these things like this, they may set a precedent that any other person that again you may invite in the committee may decide. So mostly it's a precedent issue. It's not that that process cannot be undertaken by the investigation if that investigation takes place. But maybe if honorable members are exhausted, we must give the legal services to give their opinion, especially on the sorry, on the decision of the subpoena route, but also starting to constitute a process of a don't want to say it, so when you say a commission of inquiry, a committee inquiry. Yeah, is that correct language? Ne? English is was never my first language at school. I did it second language, but I got 80%. Then Honorable Schmidt.
Thanks, Chair. Thanks, Chair. I think your summary is okay. But Chair, where we are, Chair, we are tired of not being listened to. That's what we were saying, Chair. Now, hence we were saying we didn't finish investigation, and therefore we must be subpoenas to come first. Now, on a matter of principle, we have two. Automatically, when it responds to, after the investigation, we'll be able to move to our second proposal. So that's where we are. I think we are agreed, all of us, on this particular motion, Chair. What we need a process to go forward. Now, we don't want to deal with those details of it, but you can hear what you call the recommendation and whatever. What we want that second meeting, that meeting that we can't have, the way which we're supposed to be today. We subpoena him for that particular meeting first and foremost. And therefore, we deal with other matters. So the issue of inquiry, the secondary is this investigation meeting. Then the primary one that we're going to deal with is inquiry if it takes us to that particular process, Chair. Now, what we don't want dilly-dally, Chair. You write, you postpone, you agree, you postpone. No, Chair, that's what we don't want. We are clear what we want here in this table, Chair, all of us. We want him to come in the next meeting, and then we deal with these matters. And then the second process, Chair, we're not going to deal it with here in the critics. What we want, if we agreed, we'll meet immediately after the investigation meeting. We agree with the way forward. When inquiry is going to start, how is the process going to way forward? We are going to do that. That's what we agreed even before. So let's really make it a point that we know what we want, and we want that process to continue now, not later, Chair. So that's what we want, Chair. So what I'm trying to address here, Chair, it does not mean ours what we want to proceed. We don't want to sit in one place, Chair. And the time is going. Now we can't be delayed any further. That's where we are, Chair. So the second one, details of man and other things, we're not going to be part of that. We'll agree with the process tomorrow after the investigation. We're going to meet immediately we finish the investigation. And we're saying what is a need of inquiry, what we're going to deal with in an inquiry. We'll do that immediately after we finish to talk to him. So let's do that, Chair. So it's a process of ongoing. The other one will lead to the second one automatically. And now we agreed, in terms of principle, we agreed on both now. So if needs be, we are ready. So that's what we want, Chair. If there's a need of budget, must be looked at now, so that we don't come back later and say, now there's no budget for inquiry. So we want this process to intertwine, Chair. And now I think my colleagues are very clear to say there are other issues that are taking place somewhere around. And his name has come up there. You know, so there are linkages now that have been linked to. So we can't run away to that. So that's what we are trying to say, Chair. Thank you very much, Chair.
Chair, can my comment stand over until after the legal advisor has spoken?
Yes, Chief. It's Fatima Ibrahim and Ms. Pumin Gema. Thank you, Chair. Firstly, thank you for acknowledging the capacity constraints that our office is facing. Unfortunately, Advocate Jenkins is busy elsewhere and could not avail himself. So I do apologize for that, but I trust that you will welcome the advice of the two female legal advisors who females by their nature tend to have a softer approach, so you might prefer it. Let me first answer the questions in relation to the summons. Section 56 of the Constitution clearly empowers the National Assembly or any of its committees to summons any person to give evidence before it or to appear before the committee. And that would include summoning documents. So not just the person, but asking a person to bring documents with them or even requesting documents separately. That power is not, does not require any preceding action or non-action. It is a power in and of itself. In some committees, during normal oversight processes, you may just choose to invite people. SCOPA is a good example. SCOPA conducts quite a rigorous financial oversight, and by and large, SCOPA would simply invite people. But there is precedent there that where those people don't attend, that we have summons them. So most recently, the PRASA board is a good example. The power to summons is supported by NA Rule 167, which is merely a replication of what appears in the Constitution. And then obviously it's also read in conjunction with 227 of the rules, which sets out the functions of the Portfolio Committee and your responsibilities in terms of oversight. Obviously, to conduct your oversight properly, you would need to call people before you so that you can have the relevant information to make your recommendations. The procedure is fairly simple, Chair. What's required is that the committee passes a resolution to summons a particular person. And in passing this resolution, you would need to be clear as to what the purpose of summoning the person is, because the person must be afforded the opportunity of knowing what it is they called for, so what the subject matter is and what would be expected of them. The next step and the following steps all happen outside of the committee, is that the chairperson will write a letter to Speaker requesting concurrence in terms of the Powers and Privileges Act, but it's just a formality. Once Speaker signs that concurrence memo, we then address an instruction to the Secretary to Parliament to issue the summons. Once the Secretary does that, we then forward to the state legal advisors to then work with the Sheriff of the Court to formally deliver the summons. The summons, of course, will contain relevant information such as the date and time of the appearance and the purpose of the appearance. A person that fails to honor a summons or to attend will be liable for a criminal offense. But the catch here is that in terms of Section 17 of PIPLA, it says that it's a criminal offense where you don't attend without sufficient cause. So that would be the test, whether you had sufficient cause not to attend. So in other words, if a person were to be in an accident or so sick that they couldn't attend, then notwithstanding that there is a summons, we would have to accept that as an excuse. Therefore, it's important that we give sufficient days, because we must take into consideration that the formalities itself might take 2 or 3 days to get the sign off from Speaker, to get the summons signed off, and then the instruction to the Sheriff then eventually to serve. Luckily for us, the Minister has already indicated availability for next week. So I think if the committee is insistent, we can push for that date, but the resolution itself to summons would be sufficient for us then, even to if we had to change or push the date out later for 2 or 3 days, it wouldn't be an issue. We wouldn't need to come back to committee for another resolution, because you have already resolved to summons the person. Then in terms of an inquiry, the NA rules in particular, as I mentioned, 227 sets out the functions of the Portfolio Committee. And it specifically says that the Portfolio Committee may monitor, investigate, and inquire into any matter concerning any executive organ of state. But I'd just like to distinguish between legislative inquiries and oversight inquiries. So they're two distinct processes. What's happening in Eskom at the moment in public enterprises, that is what we would call an oversight inquiry. What happened in SABC, again, would be a statutory inquiry. The difference being in SABC, you had statutes saying that the removal of the board required certain processes and investigations that Parliament had to undertake, which then it did. So There are no set rules or procedures in terms of how that oversight inquiry would need to be conducted. Section 57(1) of the Constitution provides that the National Assembly determines and controls its own internal arrangements, proceedings, and procedures. Therefore, the committee would need to decide, as you mentioned, Chair, whether it requires the expertise of an evidence leader, extra support staff, and so on. At the end of the day, however, the responsibility for oversight lies with members. Members cannot shift their responsibility to an evidence leader or to any outside third party. You would still need to take control over the process, and of course any recommendations that you make would need to be sound and rational based on your involvement in that inquiry. The difference then with the statutory inquiries, you would have a start and end date. It would be more rigid, whereas an oversight inquiry, its natural process would unfold, and you may even decide as you go along which other witnesses to call and so on. In terms of calling or summoning the minister next week and then later again in the inquiry, there is nothing in law that prevents you from summoning the same person twice. So I don't see that that would be problematic. The main difference between summoning somebody and somebody just appearing before the committee ordinarily is that when you summon somebody, they then appear and take an oath or affirmation. And what they say, even though they're protected, they're only protected to the extent that they don't perjure themselves, so they don't deliberately mislead the committee, because that in itself would also be a criminal offence in terms of the Act. So the committee is... the committee may decide on the way forward whether you'd want to move with summoning the minister and then instituting your formal inquiry or investigation as allowed by 227, or whether you would want to do the one first, so start your inquiry and then call the minister, but it's entirely in the discretion of the committee. But just a formal resolution to be noted that the committee resolves to summons the minister, and then our office will follow the rest of the processes and the formalities to ensure that that summons is delivered by the sheriff. Thank you, Chair.
Let me look at all of you in your faces. We are going to be bush lawyers now. Maybe before the honorable members would ask this question, can you summon someone who has not refused to appear before the committee, who has given you reasons for not appearing in the committee and has made a commitment to appear in the committee? Or must I put it simply rudely, can you summon someone on the basis of frustration? Because, no, I'm just asking this question because the fact of the matter, like I know it's a sensitive matter. Like I made an example to say, reasons were given. Let me respect, I know when it said at least it's women, we are very sympathetic. You can't fight with them. I tended to have, and I think some members of the committee, we had a problem even when was it the first or the meeting of the 24th? We had a problem with the rules of Parliament. They seem to be applying so much flexibility to a point where, now in this case, there's nowhere where you've got someone who says, I'm not coming. Nothing. But I just wanted to get that clarity before Honorable Manager, if you can bear with me.
Chair, as I mentioned, there are no prerequisites to a subpoena process or to a summoning process. The power simply appears in the Constitution that the committee may summon somebody. So it's not that anything has to happen before or not happen before. It's not dependent on anything. However, obviously good governance, courtesy would dictate that you give people the opportunity, which I think the committee has indeed done. It appears over several requests in the last few months. So strictly speaking, legally, there is no requirement that anything would need to proceed. Of course, as I said, the important thing, though, is that notwithstanding that you've summoned somebody, it would only be a criminal offence, non-attendance would only be a criminal offence if they're not able to show sufficient cause as to why they then did not appear in terms of the date that, that is on the face of the summons.
Thank you, Mr. Chair. I think from the past few attempts to ensure that the minister attends the committee, it's clear that we need a subpoena. I mean, it appears on the face of it that we'll have another excuse next week or whenever. So I would suggest that we do take a decision for a subpoena. My only concern, and that is, and maybe it's one which the legal advisor can indicate, if we subpoena the minister and say we need your input, he may or may not say, well, you know, you've already taken a decision to lodge a formal inquiry. Now, what is it that you expect of me? To testify at your informal interaction, let's call it informal interaction, where you want me, let's say, next week, and then you've already taken a decision, you will then have to hear me for a second time, because on the basis of what you are now expecting me to come and testify before the committee, or come and answer before the committee, because you won't be testifying in the informal process next week. You've already decided, so what is the rationale behind summoning me twice to the same exercise? Because we will expect him, and I would suggest that we call him again in the formal inquiry, because it would not be a full inquiry if you don't, once you've taken a decision to lodge a formal inquiry, not to call him again. So would there be any legal rationality argument to say, listen, but how can you, right from the onset, foresee the possibility you're going to call him twice? And now you've taken the decision now. So all I want to, it's more on the legal issues, not on the whether it should or shouldn't happen. It's whether it's rational to say, I'm going to call you for, I'm going to subpoena you, and I'm going to expect you to testify on this at this formal inquiry.
Okay. It's a tough one. We are all trying, isn't it? We are all trying. I'm looking at the point that Honorable Schmidt was raising, and makes me go to the second question. So that the discussion does not seem as if it's about subpoena. And I'm thinking, as honorable members are speaking, that maybe we might get carried away too much about the subpoena, not about what the work that the committee is supposed to do. And again, I will allow legal services if they want to have a take on this thing. Are we compelled? Again, it may sound very, I don't know, strong word to use. Are we compelled to grant the minister a second chance if for us as members who are satisfied now that we have done all that is possible? Or should we say this is what is next? That is the first question probably I think we have to. So the point I'm raising is that if we feel that only an inquiry will do justice, do we have again to sit and say, hey, next week we may not get the minister, and then we sit down and say, what do we do again? Or should we say, we put in a subpoena, then we'll wait for the subpoena, it takes another 2 weeks. I must say this thing because to some degree, honorable members, it reflects on us. So sometimes when you go out, it's like, hey, these people are not serious, you see? But the basis exactly of what we say, to say, well, a subpoena can just be at the decision of the committee. But I still believe a subpoena is someone who is resisting to appear before the before anybody that is conducting either an investigation sorry, or oversight. Otherwise, we have had this discussion before as a committee when we say someone, sorry, but to say someone is like someone resists to come, you see. That is how literal we interpret English, some of us. Now, I wanted to check with honorable members. Is it wrong? And I don't think, you see, that is why again you can come in and help here. So that we address that question, which I don't think necessarily. Generally, there were members who were not satisfied with the answers that were given. But there were members strongly who felt that, look, we must go to the next process. You see? But we had to weigh, especially from a chair's point, we had to weigh because an impression, if you had said, go ahead with the next process, would have been created that you want to protect this person not to appear in front of the committee. Then said, let's allow that process. So the understanding that from a chair's point of view that I have, sorry, it's you, honorable member, or it's us as a committee that wanted to continue with the questions to the minister. So I am asking this question. Is it not up to us to say, we tried that one, we are satisfied with it, we don't accept any further request to appear, we are taking this process now. And this is the process that if it requires to be, it will give a second chance to the minister to come. But the second time is coming, is no longer coming now in the form of the general no longer in the preceding process as prescribed by, or described or suggested by the House Chairperson. It is now on the basis that we are conducting, you say, an oversight investigation or oversight inquiry. On my side, I say it's a committee inquiry. Either way it goes, which means it's more formal. It has got more to do with what we were saying, that we are under oath. Initially, we were not dealing with that process because we were interacting with our minister in the committee. So if we go to this route, then that becomes the route that we are taking. And then we then say, any other presentation, if it comes, will be made in that particular process, where now every person is a subject of interaction. I don't know, honorable members, but I want to manage this thing so that, not that I want to pin down, but to go this route of a subpoena, I respect rules of parliament, but it may take us a little bit detour from the actual work that we are supposed to be doing. So I wanted that, so that if we then concretely say so, we can then say, on the basis of that, these are the requirements that this process will need. If we then say, before the end of this week, or by next week, Tuesday, instead of going for the normal committee process, we just meet for an hour or two, look at what we want to suggest as a way of constituting an inquiry on this matter, including the areas of focus that the inquiry will attend to. We then go straight there. No longer a discussion whether it's an inquiry or not. It is just precisely what will be the key contents of that inquiry, what it will focus on, what are the required tools, both personnel and administratively. Honorable Khawula, Honorable Jafta.
Thank you very much, Chair. Chair, I think we are getting closer to each other on this one, because what informed my initially request for clarity in terms of whether subpoena should precede the investigation or not, I was also battling with that rationality that Mr. Smith is referring to. But without laboring on it, I think all of us now, we see the irrelevance of having these two processes at the same time, resolving on two processes at the same time, subpoena him on the basis that it did not come today, and at the same time resolve on investigation. Now, from where I'm sitting, I want to check, Chair, if perhaps we cannot take a decision to then say that, given all the explanation we have received and also the time that was given to the minister to come, it's a clear indication that he does not want to come. And also, perhaps the honorable members, through their caucuses, as they could be allowed by you, to take a decision that we abandon that process of asking the minister to come and respond to whatever questions were outstanding. Instead of proceeding with that process of subpoenaing him for this particular purpose that was in the agenda, we abandon that process. We then proceed directly to the committee inquiry, as you referred to, and therefore start a process that talks to an inquiry rather than a process that is asking him to come and explain and respond to some of. So we basically take as if this agenda which we had today, we are now abandoning it because of we have given up to the minister. We're actually going to ask him to come for an inquiry, which leads me to another question that I want to check. Whether do we have a list of people that would like to subject them to the same process, as we have indicated that we want to follow the same route that public enterprise had, where there were a number of people implicated. So you'll guide me. I just want to check so that when we come to the issue of terms of reference, we don't just get stuck to one name, which is Minister Zwane, but we also check if we do have a list of other people that we think have a role to play in terms of accountability to assist the committee on this particular matter. Otherwise, I want to persuade Chair that perhaps the best way is to abandon this process of subpoenaing him specifically for this purpose, engage directly to the inquiry, and then if the need arises, we'll then subpoena him specifically for the inquiry. Thanks, Chair.
No, thanks, Chair. Given the explanation that Honorable Schmidt has given, and also the legal team, Chair, I think I stand to second Honorable Khawula that we have given the minister enough opportunity to come and appear before this committee, but in no vain. Then we now, especially that there is nothing that prevents the committee from just beginning the formal inquiry on this issue of the state capture. We just do that without saying to him maybe must come next week, or because all is the one that he will be coming, he will be given an opportunity to come and put his case before that committee when it is formally opened also. I think we just need to take that route without wasting a lot of time on this matter.
This may be the only time.
Well, those were some of the live visuals coming in from the Portfolio Committee. Of course, also confirmation that Mosebenzi Zwane has not appeared now at that committee meeting this morning. Well, moving on.
Honorable members, no, I think the only thing, Honorable Khawula, we can't abandon a process that we have not undertaken. We have not undertaken the subpoena. It's just one of the options we're considering. The issue was that that process of the minister appearing, it's there. It did take place. The only thing was that members felt that they still have got other. So we then say, we'll put that aside, and which is, I prefer that word. Rather, when you say you abandon, it's like you are running away, then you are leaving everything. You see, yeah. It's only cowards who run away and abandon everything. So we say, and the second thing, I think members must be upfront so that when the interpretation is made, it's not that of the chairperson. I get a sense that members say they don't accept the reasons that the minister is giving. So we must be clear so that the record must state that the committee does not accept the reasons that the minister is giving or has been given. Honorable Shaft, on your point of order.
No, not a point of order, Chair. I want us to avoid maybe to say we don't accept the reasons, but maybe we say the minister may have some other reason not to appear even in the near future. because if you say we don't accept, then but it means the minister, even if we say he must come next week, he may have some other reason for not coming to the office.
I'm lost. My understanding is that the minister has written to you as a committee, or to us as a committee, so that it don't sound like I'm excluding myself. But I'm just talking to you as honorable, has written to us as committee to give us a reason. There are two things that you can do then, is to accept the reason that is not appearing in the committee and is requesting to appear in the committee next week. That is the first thing. We have to accept that. But members seem to say, hey, we've been patient, taking every reason given. I want to be clear that we are clear. We now say we no longer want to follow what we asked to do. We are leaving the issue of asking these questions to him, but we don't accept, because we don't accept the reasons that he's giving for not appearing. On the basis of that, because also I don't want to have this argument as if the question of the inquiry was conditional. You see, it was not subject to. That decision could have been taken even when the process, but we said, be fair, so that the minister, for members, you must also understand, it was not giving minister a chance. It was giving members a chance to exhaust the questions they had. You can only give the minister a chance if he is a subject of an inquiry. Then the rules of fairness and equity will dictate that he must also be given a chance to rebut any evidence that would have been presented in the inquiry by any other member. So the reason I'm saying I'll be in a dilemma now is that then we must agree, then we accept the minister to come back next week, and then we'll take a decision next week on what will be done. I'm not sure what will be, what does that say in the process, because then it means we stand a long route to go. I had thought if for instance, I would have asked the question maybe differently to members. In light of this, maybe sorry to restart the meeting afresh, so that as you discuss, I think, you will represent Honorable Paulsen in his absence. In light of this, do you still, honorable members, want to ask those questions that you felt were not sufficiently answered? You know, there's something that says if an item is on the floor, if it's withdrawn, then there's no purpose of even discussing it. Do you still want to ask those questions that you had requested the minister to come and answer and finalize them? Honorable Schmidt, Honorable Khawula, Honorable Lorima.
The full answer is that in light of his poor explanations and his failure to attend, we take a decision that we proceed to a formal inquiry, and those questions will be asked at the formal inquiry.
So you are withdrawing those questions?
Not
here?
withdrawing. We're going to ask them at the formal inquiry.
No, the reason I'm saying is because this is a normal process. So you withdraw them here, not that you can't withdraw them in an inquiry because the inquiry is not started. So we can't prejudice you because of this process. But if those questions are still there, it might be difficult to say we are going to the inquiry. So I'm saying we are withdrawing them from here. You reserve your right to raise them in the inquiry. Okay, Honorable Khawula?
Chair, thank you very much. Chair, the one we must put on record that the reasons that have been forwarded from the EFF, we don't accept them. And it gives an indication that there is no appetite from the minister to respond to those. And therefore, we then take a route where any clarity that we want, we will ask them in the inquiry. We think that this committee must proceed to the inquiry, and it will give us enough time to ask anything we want to ask in that inquiry. the non-attendance and the petty reasons that have been forwarded are unfortunately unacceptable and basically indicate that the minister does not have appetite to respond to them. So inquiry is the right route.
I'm of like mind with my colleagues.
Okay. Honorable members, being the case, members say now we go for a committee inquiry or an oversight inquiry. We agree that we will come back and converge, probably even if it's Tuesday, for an hour or two to look at what, surely obviously we'll interact with our colleagues, we'll interact with the legal services, we'll also interact with the House Chair on how to constitute a commission, a committee or an oversight committee of inquiry. We will look at what type of machinery that is required, whether it's human personnel, whether it's administrative personnel. We will deal with those issues and then be able to come back and say this is how the process is going to be followed. Then as a committee, we look at the areas that the what do you call this thing? That inquiry will be focusing on, including the point that Honorable Khawula is raising. The issue, Honorable Khawula, I must say, without preempting that discussion, what would say, that instruction or that command, whatever you call it, comes from the House Chair specifically saying we must conduct an investigation on the allegations of state capture, which involves the Minister of Mineral Resources. That's what it says. It actually means we'll have to conduct an investigation whether at a balance of probabilities or political influence, has there been an undue influence on how issues are conducted in relation to mineral resources. So if there are any other people, it will also be a subject of how the evidence gets collected. It could be something that says we'll come back here, that says, well, what do you call this thing? You can make a public notice. I don't know, but we'll look at it when we consult. Can make a public notice, anyone that the committee is undertaking this process. Anyone who is things that can be able to provide. Then with that evidence, leader and legal services, you can then be able to narrow down what would have had as submissions. It will then be able to determine. It might happen that on what is being submitted, I'm not saying, they may come back and say, looking at all what has been submitted here, we don't think it's relevant or it helps us to go through a process where we say it can address the issue that the committee is supposed to do. It may come back and say, these are the people that by their own submission, or these are the people that will require to appear. And it must be clear, honorable members, it doesn't mean when someone appears in front of the committee is going to say what you want to hear. That person may come and say something different. Let me give an example. You might need, who is this person from, is it Glencore? The CEO is. I do not want to mention the name. Just wanted to say the person. If you require that person, he may come here and say, no, don't worry, everything went well, that transaction and everything in our view. So it doesn't necessarily mean when you say this person appears, you are saying it's simple because these can help to pin down so and so. May just come in and clarify to the committee. As far as we know, there's nothing that was acted untowards. There was no I don't know. I'm just making an example. But others may come and say, hey, this is what. So that information is the one that will assist. We are not looking for something that will say there was wrong. We are looking for something that says this thing should not have been done in this way, or something that says, no, on the basis of this, this is what we have been able to discover. So either way, it is a subject, it will be a subject of the outcome of the investigation. But having said so, anything that you want to legally help us if we resolve outside parameters of our mandate or the rules of parliament and the rest. But surely, honorable members, we will write to the minister. We will also indicate to him that this is a process that we follow, and in the event any other things emerges, he has got a right to the committee to appear, but also the committee may require again his evidence to be made directly. So it's either way, because we don't want to create an impression that we are the only ones who will. If he feels that also, no, I'm not being treated fairly, or the issues that are being raised are not accurate nor correct, he has got a right also to say, can I be given a chance to clarify myself? Any other matter? So I can go and do loan, Yeah. On that note, honorable members, this matter is put to rest. Please be on alert. We may not meet on a Wednesday, as usual or as normal, but we will still look around. We may meet on Wednesday. What I know with this parliament these days, things they are flying so fast. Anything is possible to happen. I'm told, Honorable Matla, from later today, your phones will not be closed, even if it's 1 o'clock in the morning. Every one of you is expecting a call. I'm told those calls, when they come, they are private numbers. Just close your phone. Okay, honorable members, thank you very much. The meeting stands adjourned.